Undue influence applies to a broad variety of documents and transactions. It's not just wills and trusts. Of course, they are potential subjects of an undue influence claim. Contracts can be the subject of an undue influence claim. So can deeds. So can lease agreements. So can gifts. Adding another person's name to a bank account can be the subject of an undue influence claim. In order for a legal document to be valid, it has to be the product of the maker's free will. Undue influence is a legal concept that says the maker's free will has been interfered with here. In fact, this document is not the product of the maker's free will. On the contrary, somebody interfered with the maker and caused the maker to sign this document, which does not reflect the maker's free will, does not reflect the maker's intent. Instead, it reflects the wishes of the interferer, the influencer. This is the concept of undue influence. And if you prove undue influence at trial, if you prove that a certain document or transaction was the result of undue influence, then the probate court will rule that that document or that transaction were invalid and have no effect. There are three factors that are particularly important to proving undue influence. First, whether there was a fiduciary or confidential relationship between the alleged victim and the alleged influencer. Second, whether the influencer had the opportunity to spend time alone with the victim. And third, whether the influencer received a benefit from the victim. If those three factors are present, then the law will presume that the gift or the benefit was the result of undue influence. In that case, the person who received the benefit has to disprove undue influence. They have to prove that there was no undue influence and this gift or this benefit was really the free will and intention of the person making it. Undue influence can be kind of challenging to prove in a court of law, and here's why. If one person is unduly influencing another, that doesn't typically happen out on the street corner. It typically happens somewhere behind closed doors with no witnesses present. And so it's very rare to have an eyewitness who comes in and says, yes, I was there, I saw the undue influence happen. It's just very rare. Typically, by the time the undue influence arises, the alleged victim is either deceased or incapacitated, so they can't testify about what happened. So there may only be one person left who was there, and that's the alleged influencer. And they're certainly not going to admit that they did anything wrong. And so the law permits undue influence to be proven by circumstantial evidence. What does that mean? Well, let me give you a fact pattern. Let's say mom had a long-standing estate plan. She had a will in place for many years, and her plan was to leave her estate to her daughters in equal shares. And then influencer came on the scene 2 or 3 years before mom died. Let's say influencer was maybe a visiting nurse. And after influencer came on the scene, things started to change. Daughters found it more and more difficult to gain access to mom. They found it difficult to get mom on the phone. They found it difficult to get entrance into the house to visit with mom. Mom seemed to give more and more power and responsibility and deference to the influencer. It's as though the influencer became the most powerful figure in mom's life towards the end. And if you imagine that historically mom had had her several daughters on the inside of her innermost circle of trust and affection, what it's almost like is they've been expelled from that circle and influencer has taken that place. Influencer is spending a lot of time with mom, and then mom dies, and we find out that shortly before her death, she did a new will, disinheriting the daughters and leaving everything to influencer. That fact pattern is not necessarily ironclad proof of undue influence, but it is circumstantial evidence that raises concerns that undue influence occurred. If I'm defending an undue influence case, there are certain types of evidence that I really like to have in my corner. I like to have a document that's drafted by an attorney, particularly an attorney who had a long-standing relationship with the deceased person and was long-term familiar with that person's wishes. I like to have a deceased person who had strong mental capacity, and it's really helpful if there's evidence that the deceased person was strong-willed and not easily controlled or manipulated, because that's totally contrary to the idea of undue influence. We have a lot of experience with undue influence claims. We represent clients who bring undue influence claims, and we defend clients from undue influence claims. People come to us to help to have us assess the merits of a potential claim. We also work with clients to assemble evidence to either prove or disprove undue influence. So if you're dealing with a potential undue influence situation, we'd really like to talk with you.